San Francisco Ethics Commission for December. I'll call the roll. Vice Mayor Chu, Vice Mayor, I keep making you mayor. Well, it could happen. In fact, you could be elevated right now.
Here.
Vice Chair Chu.
I'm here.
Commissioner Rennie.
Present.
Commissioner Kopp.
Here.
Commissioner Lee.
Here.
So everybody's present. And we'll now have public comment on matters appearing or not appearing on the agenda.
I'm Bob Planthold. I want to say that during the time off that you have over this holiday season in the next few weeks, it's time to congratulate yourself, but also maybe to take stock and see what else is ahead of you, not just in the work plan, but in what you've done so far. Is it adequate, appropriate, responsive? Specifically on the Accountability Act, I think you passed something that was too narrow in its application by only applicable to a commissioner for groups, agencies, people with business before that commission. The very fact that there haven't been problems reported is because there was no such prohibitions before. I can see scenarios where somebody from, such as, let's say, the Fire Commission, could go to contractors who may be having business before Building Inspection Commission or Human Rights certifications and seek some donations. And a commissioner from one of those other two going to people appearing before the Fire Commission. I can see a back and forth cross-channeling of efforts to raise money. So I think it's still too narrow, and there's going to be a lot of you scratch my back and I'll scratch yours unless you revisit this. And considering that the soups are going to have their bite at the apple, when it comes back, whatever changes they suggest, maybe you want to reopen the narrowness of this commissioner prohibition on these. Thank you.
Thank you.
Good afternoon, Chair and members. Patrick Minute-Shaw. 14 years ago, voters passed Prop C, requiring the Board of Soups to enact a whistleblower protection ordinance to protect city employees from retaliation. In May 2015, the civil grand jury issued its report saying the whistleblower protection ordinance is in need of change because the Board of Soups had failed to carry out their mandate to pass a genuine to pass amendments that would genuinely protect city employees. Nearly 3 years after the grand jury issued its report, there's still been no action. This commission approved your WPO amendments on March 28, 2016, and you submitted them to the Board of Soups. The jury's recommendation 1.3 clearly stated that if the board failed to act, this commission should submit WPO amendments directly to the voters. The board has failed to act for over 2 years. So you should act quickly and place WPO amendments as you had submitted them to the board onto the June 2018 ballot before the February submission deadline. Amendments ethics submitted had recommended providing anti-retaliation protections to complainants who make disclosures to county, state, and federal agencies. The supervisors removed that provision, and you should act to reinstate it, along with other protections you had included in the amendments that the supervisors have further deleted. And Judge Claudia Wilkin noted during Dr. Derek Kerr's wrongful termination lawsuit, it's long past time that the extant language in Sunshine Ordinance Section 67.22 67.d and 67.22e that provide First Amendment protections to city employees should be and must be replicated into the Whistleblower Protection Ordinance, Section 4.115A. This commission should ensure those First Amendment protections are added to the WPO. City employees have First Amendment rights, and it needs to be expressly stated in the WPO. Thank you.
Thank you.
Have a comment? No one else there? Good evening, everyone. And as I stated in the police commission in the same room last week, I want to give my condolences to Mr. Ed Lee. I've been knowing Mr. Ed Lee longer than just anybody that's been talking about. I've been knowing Ed Lee years before he got into politics. I knew him when he came every time Jesse Jackson flew into town. Him and Mabel Tang was with the Rainbow Coalition. At that time, I was the executive director of the WAPAC, Western Addition Project Area Committee, which is the most powerful black organization in the United States. It was the first PAC that fought against the urban renewal and Justin Herman. And ironic, reading in the paper today, and I'm gonna get back on this, there is some real estate guy, and I'm gonna have to talk to the Examiner for having fake news, alternative news, talking about a real estate guy want to try to rename Justin Herman after Ed Lee. Now, I respect Ed Lee, been knowing him, but oh, to the hell to the no. Because the stories really haven't came out about Ed Lee yet. Not one black official, except for London B, where I call Queen B, and Willie Brown, has anything to say good or bad about Ed Lee. But I am giving him respect until they bury the man, because I know his kids, to talk about the real Ed Lee that knows me, ACE. Now, I'm here basically telling this agency I very much respect y'all, and next year we're going to roll together, because the corruption is still here in this city by the bay, where everybody thinks everything's okay. And now we got Queen Bee at the top of the heap. They still think they ain't going to hear from me simply because she happened to look like me? I don't give a damn. Whoever sits in room 200 is going to have to hear of what the ex-mayor, the next governor, Newsom said about the outmigration, which the black, not the African-American outmigration, is the black outmigration. I'm not African-American, ain't never been to Africa. So we're going to have to differentiate when we get to the 2020 census to talk about African-American and blacks, because if you eliminate African-Americans from our black race there, you see our population is damned down like this. So my name is Ace. I'm on the case, and I'm on the case. I respect. Rest in peace, Ed Lee. But damn it, what happened to the Fillmore Street? Now, I'm here to speaking with y'all because I very much support y'all. Y'all are the only agency that I have to bid some corruption, bring it back to where it's supposed to be. Pay to play. Y'all need to put in there pay to turn the other way, because a lot of them, including my black people, are turning the other way and they know corruption is going on. Anyway, got 5 seconds. I'm glad to be here. Rest in peace, Ed Lee.
Thank you.
Good afternoon. I'm Larry Bush from Friends of Ethics. I would just start by noting that I've known Ed Lee for over 30 years. We started together working in Mayor Agnos's office, where he was the first whistleblower, ironically. And he also headed up the Human Rights Commission, where he stood firm against rigging contracts for people. He was not a person who believed in corruption. He was someone who did not have so much of a vision for the city as he was good at implementing visions that others had, which may explain how he ends up being in the news stories for a pay-to-play episode back in the 2015 election. And I brought copies of these articles because This is not about Ed Lee. This is about a political infrastructure at City Hall that operates for the benefit of political insiders. And it does so by threatening people's contracts and threatening their approvals. And they are spelled out pretty clearly with the mayor's own staff being quoted in the stories saying that there has to be a penalty for disloyalty to the mayor if you contribute money to the person who the mayor opposes, or if you don't support the person that the mayor does support. And it's a list of, an extensive list of lobbyists, city contractors, city unions, and others who were called to this meeting and told that they had to give money, with Ron Conway saying that he could not write the checks that he had in the last election because it wouldn't look good, but if they would give money, he would give money to their personal causes to compensate them for having given in a political cause. So I am asking you in this meeting today to set a hearing at your next Ethics Commission meeting to find out exactly what people will tell you on the record under oath, because at this point, my conversations with the City Attorney Dennis Herrera is that when he went to try and find out the facts, he was unable to get people to testify about it, which is odd since it's on the front pages of most every newspaper, and the people would talk to the reporters, but they wouldn't talk to the enforcement officers. And they said that they didn't want to talk to the city attorney because they didn't want to get caught up in an investigation. Well, I think the Ethics Commission has an important role to play, and it's directly related to the issues that you've had on behest payments, because this is not about someone soliciting from a person who has business before their commission. It's about people who have business before the city of all kinds, and so I think that it's appropriate that this now be put on the agenda. Thank you.
Thank you.
Good afternoon, Commissioners. I'm Charlie Marsteller for the record. I support Mr. Bush's statement wholeheartedly. I too have heard that story, and it's something that you may have heard about, but I think you need to be briefed on in case you have not been informed about it or as a unit informed about it. I brought my Christmas presents today and distributed them to the members of FOE, but since they were Bitcoins, I've decided not to give you your copy of it. And I just wanted to let you know I don't want any conflicts of interest between us, especially starting in the new year. I do also want to tell you that I attended the Represent Us meeting last week. They had a bit of a get-together with new members, and we discussed the fact that you were changing your calendar, and they were all very disappointed because all of them clearly were working individuals who would not be able to easily attend meetings at 1 o'clock. Not that that should stop you at all from doing so, because I understand the constraints that you're under. But I do want to say that really speaks to the need for your educator outreach representative to figure out a mechanism to involve people like RU members who are not able to regularly attend your meetings. And my thought is that this is the way RU, for example, trains or introduces their membership, new members, to ethics and corruption in San Francisco, and they bring their members, their new members, to these meetings for that purpose, expressly for that purpose. And the new group of attendees at the party the other night were clearly looking forward to attending these meetings until I told them that we were switching the calendar. So it might be that there's a mechanism where you can regularly meet with the newcomers to groups like RU, the younger people that are working, because we do need desperately to cultivate younger individuals in this process of watchdogging ethics in the city. All of us are getting old, and as you can see from the canes, we're getting disabled, and not that our enthusiasm has waned, it's our bodies that are giving out. So that's the comment I wanted to make, was that it's very important for us to nonetheless reach out to the younger members of the city, particularly the working professionals or even individuals, any individual who's interested in participating in this process and keeping an eye out on good government in the city, because obviously we desperately need it. Thank you very much.
Thank you. Any further public comment? If not, then we'll move on to agenda item number 3, discussion and possible action on the draft minutes for the Commission's November 27th, 2017 regular meeting. The minutes are attached to the notice. Commissioners, any? Commissioner Kopp.
Chairman, I note omission of a comma on page or under item 3, which I've marked a misspelled word under item 4. And with those changes, I would move for adoption of the draft minutes.
Commissioner Remy.
I just wanted to thank whoever it was at the staff level that prepared these minutes, because they were very responsive to the comments that I had made about the lack of information. I felt I was very pleased that I think these are the minutes really captured what went on, and I look forward to your continuing in that process. And I'll second the motion.
All right, the motion's been made and seconded, and I would associate myself with Commissioner Rennie's remarks in regard to the minutes. They are excellent. All those in favor of adoption of the minutes?
Aye.
Those opposed? Motion carries unanimously. We'll go to item number 4, discussion and possible action on revised regular meeting schedule proposal for the commission bylaws change. And there's an attachment from the December 8th, 2017 staff report and other attachments. Ms. Pelham.
Thank you, Chair Rennie. I regret that it is deja vu all over again. This is an item that, as you know, the Commission took up last month. And unfortunately, following that Commission meeting, we realized that we did not have complete information and we made an error. This is back on your agenda for a possible bylaws change. Again, to clarify the following. Commission meetings as proposed in this bylaw change would supersede last month's change. And based on room availability in City Hall, as well as on the ability to cablecast live fully the Commission's meetings, we needed to make a room change and a time change. The room and the time that the Commission approved last month would have provided for televised broadcast, but not for the duration of the meeting. That is something that we overlooked. So apologies for that. When we triple-checked and quadruple-checked the calendar and the availability of the cablecast, the bylaws change that is proposed in this memo would provide for a regular meeting date on the third Friday of each month, starting at 1:00 p.m. in room 416, unless otherwise noticed. Based on that calendar, all meetings would follow that schedule, with the exception of the May meeting, which would be on a Monday, May 7th at 1:00 in City Hall room 408. We apologize for having to reconsider this issue. There are extremely tight constraints on City Hall meeting rooms and the availability to telecast live, which is what our bylaws also require. So with that, we've presented this. We noticed it 10 days in advance of the meeting so that the public also has a chance to weigh in, and we provide this to you for your consideration today.
Thank you, Ms. Pelham. Commissioner
Chairman,
Kopp.
If we could make that 2:00, I would have no objection, because I have a conflict on Fridays between 12 and 1:30 or so.
Ms. Pelham?
I think that's up to the Commission's discretion.
But that would work out in terms of the schedule of the TV and all that stuff?
Yes, the rooms on Fridays are open after 12.
Okay.
I'd make such a motion.
Commissioner Kopp has moved to amend it so that the meetings begin at 2 o'clock rather than at 1 o'clock. Commissioner Lee.
Hi, Mr. Chair. I just have a question. Obviously, there should be no more meetings on Friday night, but is there any other meeting scheduled on the Friday afternoon after hours? I mean,
After 5
our
o'clock?
meeting,
No,
that we
not,
can continue?
yeah, not that I'm aware. Yeah, we checked that, not,
Okay, thank you.
none that are currently scheduled.
Do we have a second to Commissioner Kopp's motion?
I'll second it.
All right, motion's been made and seconded. Further comment by the commissioners?
My only comment would be, and it's directed to the staff, and the comment that was made about sort of trying to bring in those people who are otherwise employed in an afternoon. And as I understand it, there is a telephone type of connection that can be worked out. Is that correct?
Well, I think that's something we're still trying to explore. I'm not familiar with how the room is set up to accommodate multiple phone lines or a call-in. And so I'm hesitant to convey a confirmation that that's doable at this point.
All right, I would urge you to check, and if at all possible, make it so that there's a number they can call into and mute their cell phones or whatever it is until they want to address the commission, okay?
Further comment by commissioners? We'll take public comment.
I'm Bob Planthold. I'm glad you considered the change initially. I'm glad you're looking again that it's going to be widely, consistently available on TV. I support this, and I want to point out that separate from attending in person, people can monitor these meetings either through the cable TV station or because these are cable casts simultaneously. So people at work, on a muni bus, up in their attic, wherever they are, they can keep track of this. In terms of the call-in phone number, before I wrote my comments to you, I checked with the acting director of the Mayor's Office on Disability about a long-term practice of having a call-in phone line. And she verified that it is free, that it is not ascribed to any portion of any city department's budget for using it. So it's a zero-cost item. And the staff there can help ethics staff with getting whatever equipment. There typically is one extra phone. I think you're going to find a way to plug in an extra phone here in this room or in 408 as need be, because the IT folks downstairs are pretty adept at managing public communications of public meetings. So I think there need not be a problem with not having it at night anymore. People can, as they sometimes do at work, do their work with earbuds, and the earbuds may connect to some other audio information other than their work. And so suddenly when they get to item X that they're interested in, they could pause their work, dial in, and speak their piece. Free to them, free to you folks, and thereby increase participation more widely via multiple media. Thank you.
Thank you.
This is so wonderful to see that City Hall has a government agency like this to keep track of all the corruption, of all the mishappenings at most of these commissioners' meetings. Now, I just want to bring to your attention, in which I have a list of complaints I have on a number of departments, and I will submit it to you before I leave. But I want to bring to your attention one agency, which is I fought hard to bring them from where they used to have their commissioners meeting, which is the San Francisco Housing Authority commissioners, right after the mayor had announced what they call the re-envisioning. They started the PPP. And they was instructed to move to City Hall and to have their meetings videotape. But they have not done that until they haven't even done it yet. And they done been through what they call the RAD. And most of the housing authority tenants don't have a clue right now that there is no more housing authority that's the managing over their agencies. They're the developers, and developers hired the nonprofits, in my opinion, to kick the people out. Now, I'm going to ask, along with other agencies, that you look at San Francisco Housing Authority, and look at the OEWD, look at OCII, look at the Department of Real Estate, and I'm going to name a few. And this is a letter that I gave to the mayor, and I'm hoping that this didn't cause him to have a heart attack, because it was the first letter that I ever signed in 20 years. But I had told the city and county, and the mayor particularly, that we wanted to know what's going on with the addition, Yoshi's, where the city and county spent over $18, $19 million and never got a dime of it back. But they lit 1,300, a place there that used to have a commissioner that used to work with the small business commissioner, Minetta White, on 1,300. Ain't paid a dime of the money back. But on top of that, she opened up a business right across the street from where she's supposed to be closed at, they're called Black Bart. And then add injury to, she got another store out there at the airport, 1,300. So how in the heck, and I don't care if she's black, how in the heck in the community where the city let someone that was a community person then turn to a small business, and I had to go to that agency and have her kicked off, but yet she can have a business open, and OEWD and OCII don't monitor them? Well, there's a lot of things I'm going to bring to this agency. I'm 63, but I'm willing and able to be out there and to monitor and bring you back of all the wrongdoing in the city by the Bay, what we call City Hall, but I call it conveniently Silly Hall. My name is Ace. Y'all, I'm on the case.
Thank you.
Love that.
Any further public comment on this agenda item? If not,
Mr.
yes,
Chairman,
Commissioner Kopp.
in Section 4, where there's a reference to the place of the meetings, I suggest that it be the city and county of San Francisco. A matter of legal sufficiency. Thank you.
That's appropriate, and that change will be made. Any further discussion or no further public comment on this? We'll move to item number 4 then. Oh, I'm sorry. Oh, I'm sorry.
Got a motion pending.
We have a motion pending to approve the minutes, and it's been seconded by Commissioner Rennie. All those in favor of approving the minutes?
Aye.
Aye.
The bylaws, all right, excuse me. Approving the change in the bylaws. Do we have a motion on that? We don't know. We don't have.
Leave a motion. So I'll make the motion that we approve the bylaw change as recommended by the staff.
Just to clarify, Commissioner, I'm sorry, Chair Keenan, we had a motion by Commissioner Kopp and was seconded by
Okay, that's what
Commissioner
I
Rennie
Adopted.
for 2 o'clock.
That was on the minutes,
Motion
though.
to amend was adopted. Commissioner Rennie's motion is on the proposal as amended.
Okay, okay, yeah, and so that's Commissioner Rennie's motion, and is there a second?
Second.
All right. Any discussion on the motion? All those in favor of the motion say aye.
Aye.
Those opposed, motion carries unanimously. Okay. Item 5, discussion and possible action on revised Ethics Commission enforcement regulations. There's an attachment of December 13th and staff memorandum and attachments.
Good afternoon, Commissioners. I'm going to stand because
Ms.
I'm going to
Bloom.
avail myself of the Elmo projector. As you know, we've been working to substantially revise the enforcement regulations which govern the processes and procedures that staff use in order to evaluate and investigate and bring to conclusion complaints alleging violations of law in this Commission's jurisdiction. On page 2 of the staff memoranda, you'll see a list of 7 big picture changes that the regulations undertake. And through this process, those big picture changes haven't really changed at all. So within the structure of the enforcement regulations, delegating probable cause authority to the executive director, delegating responsibility for conducting investigations to the deputy director, turning the finding of probable cause into the charging document for the purposes of hearings on the merits before this commission, considering settlement proposals in public, combining the Sunshine Ordinance regulations with the Ethics Commission's enforcement regulations, and codifying the waiver policy by regulation instead of by policy. That's all remains the same in this draft that you're seeing today. But there is a little bit, some substantial changes that were made. I wouldn't say substantial, but some bigger changes that were made to the Sunshine Ordinance section that is different from the last time you saw this this package of regulations. And I want to talk about those a little bit specifically so that you're aware and that's highlighted for you. But I also wanted to advise you that we received a couple of last-minute submissions for written public comment today. And so what I would like to do and what I would recommend is that you not vote on these regulations as a final package today, to give staff additional time to evaluate those two written submissions, and then we will bring you back final language and a final package in January. So I'll leave that to you to
Well,
decide.
Mr. Chairman,
Commissioner Cobb.
may I state that I need time to evaluate Mr. Shen's comments,
Yes.
as well as these other comments from the task force. And I don't know the timing internally from an administrative standpoint, but I would prefer if I had those two documents 5 days ago and not today.
Yes.
And so that is what I convey to Mr. Shen, and I convey to whoever represents the task force here today.
Thank you. Yes. The documents that I placed on your desk or credenza are the two comments that we received today. I will say that my understanding is that the city attorney's office had, kind of an emergency situation to deal with, and that's the reason for the delay in their sending in their comments. And so we don't hold that against them, and we're happy to evaluate those comments and do a good job of reviewing and implementing them for you for January. But I do, because Mr. Young, the administrator for the Sunshine Ordinance Task Force, came today to answer any questions you might have about the changes to that section of the regulations, I'd like to sort of just walk you through those. So on page 3 of the agenda packet, I discussed those changes and staff's reaction to them. And I just also wanted to bring your attention to the exact provisions of the Sunshine Ordinance that we're talking about. So I'm going to try and see if I can get this to show up. Yeah, when I'm done, right? Oh, okay, yeah. Okay. Sorry. Okay, so it showed up. Okay, good. So the first is, in my evaluation of the Sunshine Ordinance, I discovered something that apparently hadn't been discovered before. And that is under section, at least between the two agencies, between the Ethics Commission and the Sunshine Ordinance Task Force itself. Under 67.30, the Sunshine Ordinance Task Force has the authority to send any referral of an order that they make to our commission for enforcement. That's because our commission is an identified enforcement agency in a different section of the Sunshine Ordinance. So whereas in the past, all the Sunshine Ordinance Task Force has referred is instances where they have found willful misconduct due
Ms.
to...
Blue, I'm sorry to interrupt you, but
Yeah.
just a comment I want to make, and I think my colleagues will agree that in regard to our screens up here, for the last few meetings, every time something's been put up, and we're supposed to be able to see it better on our screens, the screens go crazy. And it's,
Oh, no.
And so whoever is in charge of the technical aspect of our screens, they should take care of that. Because
Yeah.
we haven't had the benefit of our screens for the last few meetings. We just get this like 1950s TV after midnight type
wow.
stuff
Okay.
on it.
Yes, thank you. Well, I will read it out loud then.
Okay.
I'll just read it
Yeah.
out loud. So section 67.30 of the Administrative Code sets forth the Sunshine Ordinance Task Force and all of its authority, everything it's empowered to do. And sort of buried in that section, it states, the task force shall make referrals to a municipal office with enforcement power under this ordinance or under the California Public Records Act and the Brown Act whenever it concludes that any person has violated any provisions of this ordinance or the acts. So we are a municipal office with enforcement power under section 67.35, which says any person may institute proceedings for enforcement and penalties before a court of competent jurisdiction or the Ethics Commission. So because we have enforcement power, we don't have to wait for the Sunshine Ordinance Task Force to decide that someone has committed official misconduct. They can send matters to us for enforcement just whenever they conclude that someone has violated the law. So that opens the door to a few more options for us when we're considering, for the Commission, when it's considering orders of determination sent over by the Sunshine Ordinance Task Force. And that serves as the crux of the changes that I'm proposing to the enforcement regulations for Sunshine Ordinance referrals. What we're proposing is that the Commission would defer to orders of determination from the Sunshine Ordinance Task Force in terms of their findings of fact. That means that if the Sunshine Ordinance Task Force reaches a conclusion about a fact finding, or if it promulgates some findings of fact, we would defer to those findings. If a respondent appears before the Commission and presents a new fact or something substantially different, we might decide we want to consider that new fact in this context, or we could remand it back to the Sunshine Ordinance Task Force for them to consider at their level. So that way, when we are considering what the Sunshine Ordinance Task Force has investigated and determined, we have a complete picture. And then the other provision that I would change, that I recommend we change, in addition to that option to remand, is that we would review all conclusions of law de novo. So we would not rely on the Sunshine Ordinance Task Force's conclusions of law, because our commission is the only commission with the power to promulgate regulations or rules or to formally interpret the Sunshine Ordinance. So we would still have the power to disagree with the Sunshine Ordinance Task Force if, for example, they found, we have some cases in the past where they found a violation based on an understanding of the law we did not share with them. So that power would not go away. This would all take place in the context of a show cause hearing, which is not different from what we do today. So today we have the respondent come forward and the complainant come forward and present their case to you, all in the context of a show cause hearing. It's just that now we would consider the Sunshine Ordinance Task Force's findings of fact to be the complete picture unless presented with something substantially new or different. Excuse me. The other big change that you'll see is that I recommend giving the complainants and respondents in those show cause hearings, 10 minutes of comment time instead of 5 minutes. I think we've seen in the past that, for the most part, people who feel very passionately about their orders of determination, and they feel like 5 minutes is not enough time for them. The Sunshine Ordinance Task Force recommended that we give them an opportunity for rebuttal, but my view is that giving each side 10 minutes will be enough for them to get their comment out, and rebuttal would be unnecessary. So with that, I would entertain any questions from you, and then there are many members of the public here to address this issue.
Commissioner Rennie.
I do have a question about the findings of fact. Is that a change from how the Ethics Commission has approached Sunshine Ordinance Task Force matters?
I think technically yes, but practically speaking, not really. So in my experience, I have not seen this body question the fact-finding of the task force. But what I have seen is that sometimes the respondent brings additional information or would appear before this commission for the very first time when they did not appear before the Sunshine Ordinance Task Force at all, and bring you new facts. And then you would base your decision on those new facts. And what this would do would sort of preserve the Sunshine Ordinance Task Force's role in that fact-finding process, by giving you the option to remand it to them if you would like to. But you would still be able to retain jurisdiction and not remand it if you didn't want to.
But as I understand the criticism that's been leveled at this commission is that we never uphold the Sunshine Task Force. And is that because we disagree with them on the law, or that we disagree with them on their finding of fact?
From what I have seen, it's largely been either because you disagree with them on the law or because you disagree with their finding that the violation amounts to official misconduct. So up until now, the task force has only referred cases to this body where they found they make a finding of a willful violation, which under the Sunshine Ordinance shall be deemed official misconduct. So if this commission were to agree with that finding, which is really the only thing they're presented with on the referral, you would be required, that would trigger a requirement under a different part of the charter where you ask the mayor to start official misconduct proceedings. So from my view, this commission has been unwilling to do that for the most part. So what this new set of regulations does is give you enforcement authority short of a finding of official misconduct, and it recognizes that the Sunshine Ordinance has the ability to refer cases to you short of a finding of official misconduct. So you'll start to get referrals from the Sunshine Ordinance Task Force just with regular findings and regular requests for enforcement for penalties and for injunction instead of for a finding of official misconduct.
And in those cases, we're bound by what their factual finding is,
You would
assuming no new evidence coming in.
defer. Yes, you would defer where appropriate. So there's a little wiggle room there, but for the most part, you would defer to their findings of fact. I've not really, I mean, for what it's worth, I have not really seen them get the facts wrong. They do a very good job of having the complainant and the respondent and all the parties there. They do a good job of getting the parties to talk to each other and to get information and documents from the agencies. They're not always correct on the conclusions of law. But this body has a responsibility under the Sunshine Ordinance when they're going to enforce the law to be correct on the conclusions of law, which is why we would need to review those de novo.
And those matters that we would take up then that would not be matters that would result in official misconduct would be matters, what, where there was negligence or that it was not willful?
Right, non-willful.
Non-willful, okay.
So just routine, regular violations where we actually saw a few original complaints like this where someone was alleging that the documents were redacted improperly. And so exemptions were claimed by the agency that were improperly claimed. And then the Sunshine Ordinance Task Force would have to go through and decide whether or not they were properly claimed. And if the agency still refuses to produce the documents without those exemptions, they could refer it to us to impose a penalty of up to $5,000 per violation.
I have a question.
Yes, Commissioner
Through the Chair to Commissioner Rennie. It sounds to me as if the Ethics Commission would be similar to a court of appeal if it must accept findings of fact. Have you had experience in this kind of a proceeding as a ethics commissioner?
Well, I can't call specifically to mind, but I know that the criticism that we've gotten from the public is that we don't accept the findings of the Sunshine Ordinance Task Force. Now, that may be because we disagree on the implementation of the law or the application of the law. But I do think it is if it's spelled out that in effect it is like a court of appeals where we have to take the record that they give us, and the only question we have is, did they apply the law correctly?
Yeah.
I think that is certainly, I think in my mind, that's a change in at least the public's perception of how we've dealt with Sunshine Ordinance Task Force.
Yes, I would
Well,
agree.
I have a question then through the chair for Mr. Shen. Maybe a short but incisive memorandum of law on whether that is the current state of the law.
I'm not sure if it's necessary.
You don't have to do it now, but I'd like to know in a page or two of a written opinion as to whether the law now requires this commission to accept, analogous to the Court of Appeal of the state of California, the findings of fact of the Sunshine Ordinance Task Force, and in reviewing the action of the task force, base its review upon the law? That's the question.
Sure, if I could briefly respond. So in terms of the Sunshine Ordinance itself, I mean, this is an issue that we have struggled with in adopting these regulations or formulating them in the first instance.
So I'd
The
like
suns-
to know the state of the law now, in your opinion,
Right.
before
So,
I get to the regulations next month.
right. And the Sunshine Ordinance is not specific on that exact question, which why there is this need in the regulation to spell out exactly what is the purview of the Ethics Commission's review of this task force's decisions. Because the Sunshine Ordinance is non-specific on those questions, that's why we've had to delve into these issues a little bit more precisely here.
So
What about the legislative history of that issue?
The last time we looked at it was inconclusive. And we did look into all these issues.
Well, then that makes it a horse of a different color for me.
So, just following up on Commissioner Kopp's and your comments, Mr. Shen, since it's not specific, it would then seem to be up to us as to whether or not we would adopt their findings. Is that true?
That's correct.
Okay.
That's right. No, that's right. Yeah, under the existing regulations that are in effect right now and have been since 2013. I can't tell you. The way that it's set out there, it doesn't specifically say that we have to defer to findings of fact of the task force, but rather it says in the show cause hearing, the respondent has the burden of proving the task force was wrong, basically. So we're just sort of clarifying what that means for the public and for what that means for the commission. So that's why I said technically speaking, this is a change, but practically speaking, the law was the regs were just written in a different way, but it is intended for the same outcome. And I think that the reason why there's no legislative history on the Sunshine Ordinance, and maybe Andrew or Mr. Shen could confirm this, but it's because it was enacted by the public by referendum. So there's no record of debate or legislative intent. Is that right? Yeah. Okay.
Andrew's fine.
Mr. Chairman,
Commissioner Kopp.
this is just a comment on one of the proposed substantive provisions, and that's your last asterisk, Ms. Bohm. And I raise it rhetorically, isn't it custom and practice in a disputed hearing process to allow for rebuttal? You don't have to answer that now, but think about it. And I notice just quickly that the task force recommends allowing 3-minute rebuttals to all parties. I hope all means 2 parties. And I have made a note that it seems in those circumstances, meaning in a rebuttal is permissible, that the 10 minutes should be cut. And just to provoke, I would favor cutting it to 5 minutes and allowing each side 3 minutes of rebuttal.
Okay.
Thank you, Mr. Chairman.
Commissioner Reddy.
Commissioner Kopp, may I suggest maybe a compromise would be a total of 10 minutes, and the party can reserve of that 10 minutes what part of it he or she wants to use as rebuttal, like they do in the Supreme Court, for example.
I agree.
Yeah, that's a good idea. Okay.
Very good.
All right. Let the public weigh in.
Okay.
Thank you very much.
Should we have the Sunshine Ordinance
Yes.
comments?
Hi, my name is Victor Young. I'm the administrator for the Sunshine Ordinance Task Force. It was the intent of Chair Wolf to attend today's meeting, but he was unable to make it to today's meeting due to work circumstances. And just to provide a brief summary, most of the subject matter has been covered, but the main concern of the task force is they believe that the The Ethics Commission should be only determining what enforcement action should be taken and not re-adjudicating the complaints. That's the very simple form of it. I provided a list of there's 6 points of recommendations. I provided those at today's meeting. I apologize for not providing those earlier, but I was not aware I was going to be here today until the last moment.
Okay, thank you, Mr. Young. Any questions of Mr. Young? Commissioner Rennie?
Is it your suggestion that the only role of the commission is to dole out the penalties even though it thinks that the task force has gotten the law wrong? Is that your position?
I believe the task force position is that the Ethics Commission would be enforcing the decisions of the Sunshine Ordinance Task Force.
Even if we felt that you had the law wrong? Is that?
I would not be able to speak to that part of it. I would bring that question back to the task force.
Thank you.
Commissioner
Mr.
Cobb.
Chairman, my comment on that is that the task force should inform us clearly whether that's its position, and that should be in writing.
I will bring that back to them, and we will prepare a formal memo when possible.
Okay, thank you, Mr. Young. Public comment on this matter.
Commissioners, this will be my last time coming for you today. I have some other things to do, but I'm going to wind it all together here. I would like to submit this copy, and then at the next meeting, you could pass it out to the other commissioners where it clearly says where yours truly, Ace Washington, is. I wrote a letter to Ed Lee on May the 4th. He got it. May the 3rd day, let's see, was that Wednesday, he called for a emergency department head, supposedly to tell them to cut the budget, but I think it might have been because of that letter there, and that's all because of one building, the Western Addition. Now, as far as the Sunshine Act, I remember back in the days, before this gentleman was there, maybe before your commission, we in the Western Addition brought issues about the El Hill Hutch, the African American Cultural Centers was acting up and it was doing some illegal things. We brought all the evidence to this commission. Do you know that they still said it was a conflict of interest? They couldn't do on it because those two agencies were so protected by this corrupt city and county, the Cultural Center and El Hill Hutch. At the time, and I hate to say it, but I ain't saying nothing bad about our current mayor, the director at that time was London Breed, okay? Over there at El Hill Hutch, the lady now is a commissioner with the Human Rights Commission. So what I'm saying, when I bring my complaints to y'all, it's going to go back a few years all the way up to right now where the Western Addition has been penalized, not by individuals, but by one individual, and I'm willing to have a debate with him. Because I got no allegiance to this man. His name is Willie Brown Jr. Now, Willie Brown Jr., I've been waiting for the time for him to raise his ugly head, physically speaking, not ugly. But he did yesterday because he couldn't be outdone by the senator, not even by the governor or lieutenant governor. He had to get up there and he said it. And I'm asking for investigation. He got up there and said it. I'm the one responsible for forcing Ed Lee to be a mayor. He didn't want to be the mayor. No, he did not want to be a mayor because he was not a politician. The man was a civil rights helping everybody. Me, myself, too. But when he turned politics started in 2011. Now, what I'm bringing to your attention, and I'll tell Willie Brown, he got up there and said it was his idea. He orchestrated the conspiracy. Y'all must hear it a lot in my songs. It was a conspiracy. And I'm going to tell the next lieutenant governor, maybe our governor, for him to stop saying that. Don't say you was part of that. Because that was Willie Brown did that. And that governor don't need all that residue that's finna come out. Because I'm finna tell the truth, nothing but the truth, so help Ace God. I've been knowing Ed Lee for 20, 30 years. I shook his hand when he said he was getting ready to quit, go to Korea. And he said, closing, Willie Brown said publicly, he orchestrated that takeover. I was there, I videotaped and everything.
Thank you.
It just shows you that anybody can be taught to be a politician, right?
I'm Larry Bush, Friends of Ethics. I have comments on a few of the measures in the proposal. One is on Section 5, which deals with investigations. It sets a timeline of the Director of Enforcement will notify the district attorney and the city attorney of a pending case, and then within 14 days after that, after they respond with what they're going to do, the commission will move forward. As I recall, you all adopted a policy a few months ago that said that you would not wait forever for the city attorney or the district attorney to come back with a decision of whether they were going to act. You set a time.
Excuse me, Mr. Chairman. Did you
Commissioner
direct us to Section 5?
Of the handout here,
Yeah.
agenda item 5.
Oh, you mean on page 5?
That's page 8. That
Not
says 5 at the bottom.
Not Section 5 of the draft.
No, that's Section 5.
Okay, thank you.
Oh, well, I'm not here for that reason. I'm on page 8. There's Section 5.
Okay.
That's a timeline for notifying the.
Quit imitating me by getting it all wrong.
Yeah, you do it better than I do. So, as I recall, you did a timeline in which you said if it sat over a certain period of time at the district attorney or the city attorney's office, that it would come back to ethics and you would initiate your own investigation. But that's not here in this proposal, so I would recommend that that be included in your regulations, since it was an adopted policy of the commission. Secondly, under penalties, which is on page 19, now that I know how to read the pages, the penalty factors, I think that one factor needs to be considered is the timeliness of the offense. So if it's an offense that's taking place and there's a pending decision that would be affected by a wrongful act, then I don't think you should have a timeline that will let these procedures go for months into the future. I know that that's been an issue that the commission has had in the past of how long it takes to get things resolved. But particularly if you're looking at a sunshine ordinance violation, the fact that it would take 5 or 6 months to wind its way through to this stage means that the information is really useless at that point. And in that vein, I would point out that it ought to be clear that the sunshine ordinance applies to the California Supreme Court's decision of March 2nd, 2017 of the City of San Jose versus the Superior Court of Santa Ana Clara, which held that private communication devices like an iPhone can be searched and the information on it made available upon a request as a public document. That part of the problem with the Supreme Court's opinion is that it did not set out the penalty.
Yeah.
And so it needs to, in your enforcement thing, make note that those penalties will apply to a failure to respond to a request for text messages or emails or what have you. And again, that underscores the importance of the timeliness of response. If someone takes and says, I'm invoking my 10-day delay to review this, and the matter is emails going back and forth about who's going to be the acting mayor, and that takes place in a week, what's the point of having 10 days? You would never know what was going on unless you're writing history instead of writing the city's policies. Thank you.
Thank you. Further public comment?
Commissioners, Charlie Marsteller again for the record. I'm Well, I just wanted to thank the Deputy Director and the Ethics Director for going through so robustly on these provisions. I'm sure they learned quite a bit by scrubbing the provisions and then checking back with the institutional history of the Commission over the last 20 years. Enforcement has been a problematic area. A lot of it was really tied to understaffing relative to mandates, and of course, that is an issue now as we're looking at budget cuts. But I did want to suggest to the deputy that she might want to review, really for the public's interest, the item number 6 on page 2 of the memo, the staff memo, of what will happen if a person, a defendant, essentially, does not reply and goes into denial. That is a unavoidable, has been an avoidable, I think, situation that has not been sufficiently addressed until now. And I thought it would be useful for the public to be walked through to show them the consequences of their inability to meet the realities of a charge, and that their interests, fundamental interests, are not well served. I also wanted to say that regarding the Sunshine Ordinance provisions, those were drafted, I believe, by Commissioner Harrington when she was chair. I had noted 2013, and I wanted to say that it was a very helpful exercise to try to come to grips with these ethics complaints that were coming to the Commission and were basically left in an inbox and not really sufficiently handled by our regs. But it does behoove us now to go back and scrub those regs now that we've had more experience with them. So this is our second bite of this apple, and I wanted to commend the Commission for taking that review up in the context of this overall review of our enforcement regs. Thanks.
Thank you.
Good afternoon, Ellen Sang. I was shocked to hear last Sunshine meeting, your representative spoke and said the Sunshine Ordinance Task Force, the only function is the investigating party. Sunshine Task Force issued the order determination after minimum 2 hearings, most of the time 3 hearings, sometimes more than 3 hearings to issue the notice violation. And the department really don't care about that because they know that it's just a piece of paper, there's no consequence. All they can do is asking for more budget and then get over time, come to the hearing and spoke, not quoting the law, not quoting the facts. Why do they just say that they don't have to, they don't have to provide documents? This is my own experience. Years ago, Sunshine Task Force, after hearing, referred my case to your commission. Unfortunately, I don't even have a chance to present my case before you. The case was dismissed because the investigator says there's no fact to support the finding or the order. And then the recent case I'm talking about this year, August, I make the Sunshine immediate disclosure request, ignore. And then I remind them, hey, you did not respond to my immediate disclosure request, ignore. And then I file a Sunshine complaint. Sunshine send them an email, tell them that you are required within 5 business days to submit your written responses, okay? This is a long page. And they ignore also. Before the hearing, Sunshine hearing, the representative willfully knowing that's wrong and says that once we provide her previous Sunshine request for different document on different day, we don't have to provide her anymore. And after 3 hearings now, for my August Sunshine immediate disclosure, the last hearing was December the 6th, okay? And then September, October, December. And then they finally, all the members voted against the planning department, okay? And you can look at the face. She was smiling when she walked out because there's no consequences. So we depend on you to enforce the Sunshine Order. That's all I want to say today. Thank you very much.
Thank you. Any further public comment?
Go to the lower microphone. I turn that on.
My name is Nancy Cross, and I'm here to express some concern, or at least question, whether the commission investigates a complaint. And the definition of a complaint, is it a verified complaint? If it's not a verified complaint, where is the probable cause for you to investigate? Why should you take the trouble and take the side process of investigating one side privately and then maybe the other side privately and deciding when there's no probable cause? You can't do that in a court hearing that we would have any respect to it. I'm caught in a situation in relation to the homeless department doing this kind of thing. It said, yes, we have a very wide way of a way to open the doors of the shelters if a person is 18 years old and can take care of themselves. But it gives the site shelter manager power to dismiss that person without any fair hearing and without any fair process. The shelter director can do this just right. He saw a staff member, no, not he, but somebody else told him that somebody in the shelter had attacked one of their employees, and therefore that person should be dismissed from the shelter. There's no fair hearing at all. And they have a funny little process that says the shelter manager can conduct a hearing, can meet with the person being evicted from the shelter simply in private, tete-a-tete. This is a place for bribery. This is how we get corruption. Having somebody with the power to do some great violence of putting a person on the streets simply because I said he did something to somebody else. And there's no fair hearing. There's ultimately, after you go through this process, after the person who is bringing the charge but not had made any fair hearing, made it do it, then you have arbitration. But it's not a fair process. The rules of evidence are not provided. We need to look at the people who are disadvantaged by our system to a subclass. You're homeless, therefore you're at fault. And we can steal from you, and you have no remedy from the stealing. There's no fair process. I would like the Ethics Committee to look into how the homeless situation is dealt with. The grand jury dealt with homelessness in 2002, and the Board of Supervisors suppressed the publication and never responded to, and neither did the mayor or the department, to that situation. The clerk's office can tell you all about it, and I can too if I have more time. And I think this is very much at the heart of what you could be doing and should be doing to take care of the most hit people in our community and to protect us from what the president wants to do to manage for us.
Thank you.
Point of information, Mr. Chairman.
Commissioner Kopp?
Through the chair to staff, do complaints have to be verified by law?
No, they do not. They can be submitted, if they're verified, then we're required to
And is
consider
that
them.
our law or state law?
That's our law.
Thank you.
You have any further public comment? All right, so, Ms. Bloom, will still your desire to have further discussion of this at our next meeting and in line with Commissioner Kopp's also requests relating to
Yes.
the city attorney? Okay.
Yeah.
So is there a
Mr.
motion?
Chairman, before I make a motion,
Sure.
continue it 1 month, couple more questions. There's reference to a law enforcement agency. Are we deemed under state law a law enforcement agency?
That's a matter of some debate. That's a matter of some debate. Probably not, but sometimes we try to squeeze ourselves in.
Give me a specific answer on that?
Yeah,
By next meeting?
sure.
Yeah. And then, secondly, under the California Public Records Act, can a local jurisdiction's law reduce that 10-day response?
Yes, we could be stricter.
We do have that legal power.
I believe so.
Okay, thank you.
Yeah, we're stricter in the Sunshine Ordinance on a couple of occasions.
I'll make a motion to continue this matter.
Is there a second to the motion?
Second.
I'll second it.
All right. Any further discussion among the commissioners? All right, so all those in favor of the motion say aye.
Aye.
Opposed, no. Motion carries unanimously, and the matter is continued for further discussion to our next meeting in January. We go now to item number 6, which is discussion and possible action on staff memorandum updating the commission on proposed rules addressing online political communications, and their attachments of December 13th, 2017, staff report and attachments. Yes, Mr. Ford.
Thank you, Chair. Good afternoon, Commissioners. Pat Ford, Policy Analyst. What's that? Oh, okay. The memorandum at Agenda Item 6 summarizes staff's analysis up to this point of certain proposals regarding online political communications. By way of background, on September 22nd, an op-ed appeared in the Chronicle regarding certain proposals that the city and county should take up to address perceived problems regarding online political communications. This op-ed was by former FPPC and FEC Chair Ann Ravel and 2 law professors, Chris Elmendorf from UC Davis and Abby Wood from University of Southern California. At the October Commission meeting, members of the public and the Commission expressed interest in having staff look into these proposals and analyze whether or not they could be possible action items for the Commission to take. So as a result, we followed up with Ann Ravel and Professors Wood and Elmendorf, and we had a meeting in our office on November 20th that Commissioners Lee and Chu were present at, as well as a lot of our staff members to look at different aspects of how these proposals could possibly be implemented. And this memo sets forth some of the major proposals and what staff believes would be the best way forward on these. Starting on page 2, the major proposal that staff believes is worthwhile to do further analysis of is the concept of a kind of archive wherein online platforms, think of Facebook, Twitter, and other websites that provide advertising space or other areas for people to pay to spread political communications. These kind of platforms would archive certain data about these paid communications. That data would include not the identity necessarily of the person paying for it, but the amount paid, the content of the communication, the way that the communication was targeted to particular groups. And this data would be available to the public on some kind of online database. Yet to be determined whether that would be one central database or individual ones maintained by each platform. But the general concept is that this would be publicly available information. Staff wants to move forward with further analysis of this. We think there's a potential that this could be worth implementing. However, we have a lot of questions that we would want to look into first. We think the best way to look into these questions would be to convene some kind of forum or panel where we would invite Professors Elmendorf, Wood, and Ravel, as well as other experts in this arena to come and speak with staff, with members of the commission, and with one another as to what they think are the unique challenges and solutions that we need to be cognizant of. This is a kind of novel approach. We don't know of any other jurisdiction that currently has this kind of archive. It's roughly analogous to the public file requirement that the federal law requires for broadcasting networks, but it's different and much more complex because it covers such a wider array of communication styles. Instead of just radio, television, more traditional platforms, we're talking about new and very diverse sets of communications ranging from social media to more traditional websites. So we think it would be best if we could get the brightest minds that are looking at this cutting edge area together and explore this area. At the bottom here, page 2, we laid out a rough timeline that we would like to propose to you to organize our ongoing analysis of this. So the first thing we'd like to do is to carry out that forum that I described. And we'd like to start reaching out to people shortly and exploring when we could have that. Once we do that kind of forum or panel, at the next meeting, we'd like to come and present our findings, summarizing for you what we gathered from that and what our conclusions are from that as to whether or not we should move forward. And then at the following meeting, we would come forth ideally with some kind of proposal, an actual set of rules that would lay out this kind of archiving approach if, in fact, the result of the forum seems to indicate that this would be a good idea. So there's 3 other proposals other than the archiving one that are listed here, but staff is not recommending that any of these 3 are items that the commission should take action on. Primarily that's because we think that these are already addressed in our law. So this should show you that in some ways San Francisco is actually ahead of the curve when you look at the federal system and when you look at other states' laws. The proposals made by Ann Ravel and the 2 professors are really not gauged specifically at San Francisco. They were looking nationally and at other jurisdictions. So some of these proposals actually don't really indicate things that we need to change. So one of those is the definition of electioneering communications. At the federal level, internet communications are exempted, but under San Francisco law, that's not the case. And in fact, we already get filings in our office of internet communications. So this isn't an area where we need to be looking at to expand. This is already encompassing this mode of communication. Likewise, the electioneering communications window is much broader in San Francisco than it is at the federal level. At the federal level, it's 30 days before a primary election and 60 days before a general election. But in San Francisco, it's 90 days before any election, which is much broader. And lastly, on page 4, state law has an impracticability exception when it comes to disclaimers, and the way that plays out in online disclaimers. So we're talking about political ads that have to carry a paid-for-by disclaimer. If the communication is so small that it's impracticable to include a disclaimer, the person placing that communication is able to just include a link, basically, where you can click and see the disclaimer on another place. So that's different, again, than federal law, which basically says if it's impracticable, you don't have to do it. So state law, again, California law here, going a little bit beyond what federal law does, and we believe that that's probably sufficient to provide people notice that something is a paid communication. So we are not recommending this as an area for action by you. So To wrap it up, we would like to hear your thoughts on whether or not this kind of forum regarding the archiving idea is something you're interested in having us pursue, and if so, whether or not you agree with the rough timeline that we've set out here. Thank you.
Thank you, Mr. Ford. I think she pronounces her name Ravel, Ann Ravel, just sort of as a minor matter. But commissioners.
Yes. Thank you, Chair Keene. So I am very much in support of the proposal that you lay out here. I think this is really critical work that the Commission can undertake on a matter of I think greater significance than we might realize because of the impact that it can have on our elections. And my only advice or request would be is that to not just limit our inquiry to Ms. Ravel's proposal, but to be open to other approaches as well. I think Stanford's Law and Practicum report that came out outlines a whole slew of solutions, which I think are worth looking at as well. And I also think that a forum bringing in thought leaders and other stakeholders who could help shed light on this, very fluid and initial stages of a solution to a complex problem, I think would be a very good idea.
Commissioner Rennie.
I join in Commissioner Chu's statement about supporting this. I question whether you realistically can do it by the next meeting. I think that it's such a significant issue that the emphasis ought to be on thoroughness, not on how quickly you can do it. So I would urge you to not put a timeline of January. February might be nice, but if you need 90 days to get it done right and present something to us, I would be fully supportive of it. And I strongly think it's an area, I mean, we're seeing it at the national level, the whole, what the social media impact can be on elections. And if there's a way in which we can get out front and be helpful to, at least at a transparency level, I think it'd be a great step forward.
Commissioner Lee.
Thank you, Mr. Chair. I echo my colleagues' comments. I just want to have one recommendation. We spoke a little bit briefly on the true source of funding. I know that there's a very complicated issue, but I think it's something that I think this commission may want to spend some resource in investigating. So definitely I don't think you can get it done in a month, but if that could be included in part of your analysis, that would be included in the future forum discussion, that would be really helpful. I think that currently there are laws that say foreign government, non-U.S. citizens could not be engaged in political activities, but there may be ways that we can really tighten that up to make sure that the true source should be identified. Social, internet communications.
Further discussion by the commissioners? We'll take public comment.
Larry Bush, Friends of Essex, thank you for taking up this issue. It is of critical importance to how we are being informed about interests that people have in our elections. There are some questions that I don't know the answers to, but hopefully this process will bring them forward. Currently, some of our laws provide an exemption for disclosures and reporting for member organizations that provide recommendations including for candidates. That's been interpreted by some. For example, the Committee on Jobs said that they could send it to all of the employees of all of their member organizations, which was like 50,000 employees, and it was all exempt from being disclosed. So I'm not sure under this provision whether member communications are defined in such a way as to be exempt from disclosure. Same thing happened, by the way, with the Democratic Party when they would cherry pick just one jurisdiction to put out information on an election, but because they were Democrats, they didn't. So that's one thing. Secondly, in terms of monitoring and disclosing on electronic things, when I post something on Facebook, for example, for Friends of Ethics, I don't put in a disclosure there. I report it on my campaign finances that I've paid for Facebook to put something in, but there's nothing that tells the public that Friends of Ethics material is being paid for by Larry Bush or whoever it is that I've managed to drill up for the money. So I think that there is a way of doing it that's broader than what we see currently, because I don't see anybody else putting those disclosures on either. Thank you.
Thank you. Do we have further public comment? Okay. We'll go now then to the next item, which is going to be item 7, discussion and possible action on monthly staff policy report and update of the Commission's annual policy plan. There are attachments of December 13th, 2017 staff report and attachments to those as well.
Thank you, Chair, and Commissioners. Good afternoon. Just for reference, the annual policy plan that's been updated for this meeting is on page 7 of Agenda Item 7, and the legislative tracker, I guess as we're still calling it, then begins on page 8 of this item. So to just do a little background and review from last month, we modified our policy report to set out and more formally ask for recommendations of the Commission when they're going to amend or ask that staff review certain policy items. So going forward, we have current Section 1, I guess, sets out the current ongoing policy initiatives, and Section 2 sets out those planned and pending policy initiatives. In that Section 2, we would ask that any additions or subtractions from that would be sort of formally discussed and voted upon if possible, just for staff's convenience, I guess, going forward, just so we understand the sort of policy priorities of the Commission going forward. I'll highlight a few of the items on the policy report. I'm not going to go through every item, as some of these are unchanged from our November meeting that was only a few weeks ago. But going to page 2 of Agenda Item 7 under Section 1, Ongoing Policy Initiatives, I just want to give you an update on the anti-corruption ordinance that you all voted and passed at your November meeting. The ordinance was passed along to the board clerk on December 5th. The clerk of the board processed that legislation, and that would now carry an introduction date of January 9th, 2018. That ordinance will be submitted under what is known as the 30-day rule, which effectively requires the passage of 30 days prior to the board or committee thereof holding a hearing on the ordinance. That 30 days would elapse on February 9th, 2017. Or I should say, we have recently become aware that 30 days, however, could be waived at our request by the board president. So that would, in essence, give the if the board president was to accept that request, that 30 days be waived, that would give them time to consider, give the board time to consider the legislation for a longer period. So I think I'll allow you to discuss that as we go along here, but I will move on to the next item. Skipping the Form 700 non-voting ordinance as it still is pending committee action, I will move to the ethics and sunshine training. As you know or may remember, the ethics and sunshine training regulations were voted unanimously by you all to go forward at your October meeting. The Board of Supervisors has 60 days to accept or reject the proposed regulations. The last day for the board to act on those regulations is December 23rd. If no action is taken, those regulations automatically take effect. our IT and IT compliance staff has been working to update the forms required of the Ethics and Sunshine training to ensure that they are all compiled in one document, one less form for all of the persons in the city to fill out, which I'm sure they will be happy with. Moving then on to Proposition T and the behest payment ordinance. As you may recall, those are two ordinances that both go into operative effect on January 1st, 2018. Again, our management and IT staff has been working diligently to update the processes for those forms. As far as the Proposition T, that is the Proposition T was a law that would ban, in part, lobbyists from giving gifts and making contributions to city officials. IT staff has created and is testing an electronic filing database, which they hope to have in place by the Jan 1 operational date. The same is true of the behest payment ordinance. IT staff is working to update forms and to implement a disclosure database that we hope to have ready by the January 1st operational date. Moving on to the whistleblower ordinance, an update here as we heard a member of the public speak on this item earlier today. We have continued to work with the city attorney's office and DHR to make amendments and review the whistleblower ordinance. And as you will notice, in November of 2017, it was assigned to DHR's new employee relations director for scheduling, so we can begin to move forward with that meet and confer process. We are keeping tabs on the process as it's now formally scheduled with that employee relations director. Our executive director, Pelham, may have more of an update for you on that item in her director's report. Moving on to section 2, the sort of pending items that we have in front of us. As it relates to item A, we are now on page 4, I believe, of this agenda item. Skipping down to item number 2, which is file number 170868, which is the legislation pending from Supervisor Kim. Staff and the commissioners have met with Supervisor Kim, and we are continuing to monitor that legislation and are working with Supervisor Kim's office to give our recommendations and advice as that legislation moves forward. Obviously, with the events of the last week, we've been on hold as far as this agenda item and others for that matter go, but we are continuing to monitor that legislation with Supervisor Kim. Moving on to the sort of, onto page 5, the larger items. Items number 2 and 3 in particular, the review of the campaign finance reform ordinance regulations and review of the city's public financing system. We've heard from the commissioners, we've heard from the public, and internally at a staff level, we have seen a need that we embark on these projects that have now been delayed for several months with some immediacy. The policy division is hoping to present to you all a more formalized project plan that hopefully gets those large items moving forward either at the January or February meeting, just so hopefully we don't get bogged down as we may have a bit in the anti-corruption ordinance, that hopefully sets out a path for both the commission and the public to understand about how we're embarking on those processes. So we'll hope to present you with a more formalized project plan for those two items in January, hopefully, but if not, in February at the latest. And we will update you on that as we can. Moving to sort of section or item C here, the recently identified projects. You just heard from Pat Ford on the social media election integrity project. We will, I think, move along at the proposed schedule. We heard some proposed amendments to that schedule, and we'd be willing to hear changes to the recommendation that we have here if that is the path that the commission believes is necessary. As to the second item under the recently identified policy projects, the use of cash out proceeds or the prohibition on the use of cash out proceeds. Commissioner Kopp at the last meeting had asked that we work with MOCD, that is the Mayor's Office of Housing and Community Development, to schedule a meeting and get a better understanding of that process and the policy that was adopted by MOCD. We are still working with MOCD. It's the holidays, and there's obviously been some recent events that have made us scheduling a meeting with the commissioner's staff and MOCD a bit difficult, but we are still working to get that scheduled.
To get a meeting?
My understanding at the last meeting is that you would like to hear and see the documents.
You're working to get a meeting with a city department?
Correct.
Doesn't make sense to me. You pick up the phone. I mean, this thing is going to take forever. It's going to go past the February deadline for June election action.
As I said, I think some recent complications and persons being on holidays that they feel are necessary to be in attendance at a meeting we have not been able to schedule that formally. And then moving on to our last item on page 6, the independent city attorney, it was asked in, I believe, of September or October commission meeting that this ethics staff continue to review and prepare a memorandum and legislation about having their own independent city attorney, and staff is planning to research and preparation for that, and we'll have that on their January 2018 commission meeting as planned. I'll take any questions or other items that you would like to discuss.
Commissioners. Commissioner Chu.
Thank you. So, Kyle, on the whistleblower ordinance, can you walk me through the process by which that we can get to closure on this issue? Is it meet and confer, and then what happens?
I'm going to let Executive Director Pelham take this one.
Yeah, thank you for the question, Vice Chair Chu. The status is that because there is a provision in the proposed ordinance for training of all city supervisors who would be responding, have the requirement to respond and manage the intake of potential whistleblower retaliation complaints. The bargaining units need to meet and confer over that item. So we anticipate that would be something starting in early 2018 under the oversight of the Department of Human Resources. We would be engaged in those conversations. I don't have experience to know how long those take. I would imagine it would be a series of several meetings to hear any issues and resolve any questions that they may have. But as a civil grand jury report noted, the recommendation is that we keep the commission closely informed about that process should the commission decide that it goes back to the board, it takes time, the commission may want to take a different action or different approach. But at this point, we don't have a date by which we can promise to bring it back, but we will be bringing it back. Our plan would be to bring it back to the Board of Supervisors after the conclusion of the meet and confer process, and to, again, ask that it be reintroduced and approved. It was supported by and introduced by Board President London Breed, and at her request to take it to the board or to the bargaining units for review. So we're hopeful that process can conclude and bring it back to the board for final action. We'll know more probably in the next several weeks, and we'll make sure to report back to you at the January meeting.
Okay, so that once the meet and confer process is concluded, it would go back to the Board of Supervisors for action. And if they don't act, do we have the ability to then take the ordinance and put it on the ballot?
I believe so. Any ordinance that the commission has authority to place, they could place for the areas under our jurisdiction can be placed. We'd want to make sure to give you formal writing analysis of that, but our initial take at the table informally is that we think we do have the authority to do that, but we would want to confirm that with research, of course.
Okay, thank you.
Mr. Chairman.
Commissioner Kopp.
Through the chair, with respect to page, I don't know what page it is here, page 5, I guess.
Yep.
The public financing system item.
Yes.
Last meeting, I was informed, other commissioners were informed that that would be examined under the audit of public financing for the arising from the 2016 election. Is that correct?
I'm not sure I understand the.
You're going to audit the public financing system.
We want to, yes, we need to take a look at the public financing system.
Well, what does take a look mean?
It means assess how well the law has worked, assess where there might be gaps in the law that have been problematic for candidates.
When will that be done?
As proposed here, we're proposing that we begin that process this winter, this in January, starting our research internally. Kyle, do you have anything you want to add? Or
So it's not based alone on the audit. I think we want to review how other localities are, how effective their processes have been, and compare those to our own. In addition to answering the question of what our own has accomplished and what it has not.
Well, this related to a specific charge by a supervisor that money was being used for purposes other than legally authorized. And we were informed that this would be part of your examination of the campaign public financing ordinance and system. Is that still accurate?
yeah, I want to clarify. If your question is about a specific allegation of whether there was wrongdoing, that would not be part of a policy analysis. That is something that would be handled by our enforcement staff to see whether there was any merit.
Well, I would appreciate your ascertaining if it's the latter and beginning such an investigation.
We can certainly do that. That hasn't been part of the discussion for the policy that we're going to be bringing forward. That's a separate process, but they're parallel track. So we're handling policy questions from the reports that Kyle would be working with Pat Ford and others on. And to the extent that there are any allegations about misuse of public funds from prior campaigns, that's something that our enforcement team would certainly have an interest in and be focused on.
Can you begin that in January?
So Commissioner Kopp, I think that you're right that the audits, that every publicly financed candidate is audited. And so every publicly financed candidate is undergoing an audit right now, and the results of those audits will be released, we hope, early next year. Once those publicly financed candidate audits are released, then my team would pick up at that point, if there are any material findings, and pursue an investigation into those committees.
Okay, thank you for that. Then on the legislative updates here, you've got a comment in a couple of places about legislation, state legislation, held under submission. Mm-hmm. To a lawyer and a judge, that means that there's some dispute and the judge is waiting to decide it after hearing argument. What does held under submission mean, for example, with AB 1234, Levine, Mr. Levine?
So the glossary definition there is just, that's an action taken by a committee when a bill is heard in committee and there is an indication that the author and the committee members want to work on.
Then may I suggest, in fact, may I request that you phrase that as held in committee, and whether it's a policy committee or the fiscal committee.
Just to be clear, held in committee has a separate definition under the state legislator's glossary. So
accepted what definition?
Held in committee under the glossary definition here means when a bill fails to get sufficient votes to pass out of committee and it's held in committee.
Yeah, that's what I say, but we don't say that here. You don't say that under procedural stage.
Yeah,
you say held under submission. I don't know what to me that could mean they're, I don't know what it means. And I'll just suggest that you say held in blank committee, policy committee or fiscal committee.
Thanks for the feedback, Commissioner Kopp. I think we can try and continue to evolve this so that the terms are simple and understandable to the layperson, and we will strive to do that at the next report.
Commissioner Chu. Wait, one more question. And lastly, what's going to happen with this whistleblower ordinance, which Mr. Monette Shaw commented on, in which he gave us a written two-page analysis of? Are we going to have that on our calendar in January?
We are hoping that we will have the meet and confer process I mentioned starting in January, and that as soon as that process is complete, that it would go back to the board for the board to introduce and act on. We will certainly keep this commission informed, and if it needs to come back here because of a policy change,
So we have to wait for the Board of Supervisors.
At this point, it was sent to them and it's pending with them. So we would like to get it out of meet and confer back to the board for action so it can be enacted into law.
To your knowledge, has this commission ever taken action on a proposed ordinance which requires meeting and conferring with unions?
The issue was raised as well with extending e-filing technology to all designated employees. So there was a request that that be meet and consulted with the bargaining units. I think there's some disagreement over whether it's a meet and confer requirement. We do know that there are significant questions bargaining units have, and we'd like to be responsive to that as much as we can.
All right, so there's a legal difference? Is there a legal difference between meet and confer and meet and consult?
I understand there is, but I'm not a lawyer with employment law.
I've never heard it.
I understand
Maybe
there is.
Mr. Shen, you can provide me an answer to that at your convenience.
And I'm also reminded by our deputy that under the when the city created the statements of incompatible activities for each department, they were also subject to meet and confer. And the current law also provides that if a statement of incompatible activity for a department is amended in any way, it also must be subject to meet and confer before those amendments can take place.
My point is that we're not aliens to the process of meeting and conferring, and don't have to depend upon the Board of Supervisors for action on a proposed law that's almost 2 years pending come next month. Thank you.
Just follow up on that before I recognize Commissioner Chu. I wouldn't think, Mr. Chen, you correct me if I'm wrong, that this commission's authority to put something on the ballot could in any way be trumped by any of the meet and confer requirements that the city and county has.
That's a good question. I'm actually not sure how that principle will work vis-a-vis ballot measures placed on the ballot by this commission. I would say that there's some relatively recent case law saying that if a legislative body, such as a Board of Supervisors or City Council, places a measure on the ballot, they may be subject to meet and confer requirements.
Before it going on the ballot?
Yes, it would need to be subject to meet and confer. In that way, is unlike a true sort of citizens initiative placed on the ballot via signature gathering.
Could we have some guidance on that? Because as Commissioner Kopp has indicated, and Mr. Minette Shaw had said, this is something that was, and Commissioner Rennie, when he was chair, I remember him asking many times to follow up on this, what's happening with this. This is something that we passed quite a while ago, sent on to the board, and it has some, we were fairly emphatic about the importance of it in regard to whistleblowing, for the to have these protections in place. And I remember at the time of our vote, comments by several of us that if the board did not go forward and put this and pass this, that we would put it on the ballot. And now it just sort of hangs out there and hangs out there and hangs out there. And so in regard to us going forward and getting to the point where we say, no, we're going to put this on the ballot, it would be nice to know whether or not there would be some further impediment to that in any kind of meet and confer requirement. So if we could have that from you, Mr.
Yes,
Chen,
yes,
that would be
understood.
appreciated. Okay. thank
Yeah,
you.
understood. I'll work with staff to provide you, the commission, with that information.
Great. Commissioner Chu.
Okay, thank you, Chair Keen. I was going to make the same comment, but I want to go back to the public financing piece of it, because Supervisor Kim had incorporated in her proposed ordinance changes to the public financing matching ratio 6-to-1, I believe was her proposal. So I'd like to make sure that we, as you had noted before, that stay in sync with her as if she moves this legislation forward. And I think that the city would be best served if we undertook our analysis as we plan to do, and that we could incorporate her input into that review, as opposed to having her go off and enact an ordinance in this arena.
Yeah, I just want to clarify quickly. In the version that's currently in front of us, there is no public financing pieces in that legislation.
Okay.
Merely a proposal at this time.
Okay, great.
Cheers. We'll take public comment on this.
Again, Commissioners, Charlie Marsteller for the record. I was going to say, at this point, I believe the commission, not the commission, but the Board of Supervisors would be hiring a new president, appointing a new president, or electing a new president. I don't know how that works. I assume that the acting mayor would appoint their successor for that district seat.
Yes.
But in any event, the legislative packet that she put together or had as her agenda would now be vacated in effect, and we're in need of a sponsor. So you might put on your thinking caps and see if you can come up with another sponsor advocate for this measure that we can coordinate with, and in the near term. Because I do think if your sense is that if they're going to make significant modifications and gut the ordinance, or that there's a question about it, whether it will be enacted at all, given the feedback from the public or private concerns about this legislation, that you may just want to go ahead and put it on the ballot in June, which would mean that you're on a timeline. So you want to look at that timeline and make sure you're ahead of the calendar. Thanks.
Good point.
Commissioners, Larry Bush. Friends of Ethics sent in a Freedom of Information request, sunshine request, to the city attorney's office for all whistleblower complaints related to sex harassment since 2011. And I have that information. I have now emailed you the response that came back from the city attorney's office. But since 2011, the total number of settled cases involving sex harassment is 2. It suggests that this may not be the full story. In fact, there are a number of cases that are listed with no settlement or $0, including Leanne Hepner. It was Joanne Hepner is a case that we all know, which has resulted so far in a judgment of $2 million against the city. But it shows 0 settlement in the materials by the city attorney's office. What I know from my own experience is that there is nothing that the city unions and city agencies like to do more than talk to each other without a result. And I think that unless you put a timeline of when you expect people to come back with a report, they're not going to move. And certainly nobody at the Board of Supervisors, as you look forward to the next year, is going to want to take on the city unions as they're looking for endorsements and support as they're running for office.
Mm-hmm.
So I strongly suggest that you pick up the gauntlet and run to the finish line. Thank you.
Thank you, Mr. Any further public comment? Okay. If not, then we'll. Yeah, go ahead. I'm sorry.
Sorry, Chair. I think as last time, we would just ask that you take a motion to just approve the recommendations in in section 2 of agenda item 7.
Okay, sure. Do I hear a motion to
So
that?
move.
Second.
The motion's been made and seconded. All those in favor of the motion, please say aye.
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 Opposed, nay. Motion
Okay.
carries.
Mr. Chair?
Yes,
May
I'm sorry, Commissioner.
I want to join in the concern about the whistleblower statute, because I think it is very, very important, and I would urge that if we can't get some resolution in January, that we look at putting the version on that we sent to the board without some of the amendments that they made in committee, I think, which weakened it, and put it to the voters.
You have to do that, Mr. Chairman, by when?
We could do it in February.
Yeah, so March 2nd would be the absolute drop dead date.
Yeah.
So it could be calendared tentatively for the February meeting.
That's something, yeah, that's something that, as I look at what's happening so far, I think that's something we will do. Otherwise, it's just going to be dead in the water, and we'll have to move it forward and put it on the ballot, along with some other matters as well.
Is that going to be, when you're speaking of the ballot, are you talking about the June?
June.
2016?
June, yeah.
There isn't going to be is there a?
2018.
There isn't, 2018, there isn't a 2018 November, is there?
There is.
Yeah, there's
So
both.
it could be on that ballot, and that would have a different timeline than we're talking about.
Yeah, yeah.
Fine.
It would be August then, just for August 5th, I believe.
that's-
For that one, yeah. Okay, any further discussion on? Okay, all right, well, did we vote on that?
Yes.
Okay, fine. So we'll move on now to the item, is item 8, I guess, the discussion of enforcement report, an update on various programmatic and operational highlights of the enforcement program's activities since the last monthly meeting. And there are attachments of December 13th, 2017 staff report and attachments to those.
Thank you, Chair.
Chairman, I request a closed meeting on this item.
Is there a second?
Yeah, Andrew left, but I'm not sure we can go into closed session on an item unless it's been agendized that way. So we can discuss any complaints in closed session for agenda item 10.
For which item?
We're on 8 right now, so we would just
No,
have to.
we're on 8. but
Yeah.
Which item you say we?
On 10, we can go into closed session.
Oh, all right.
Okay.
Okay.
I defer.
Thank you. Thank you, Chair. For the public part of the report, the Commission received 5 new complaints since November 17th, which was the last date that we reported to you. 29 matters await either my review or Director Pelham's review. That is a regrettably large number of items. I will confess that to you, but we were very busy over the last 3 weeks. We went to Kogel, which is a feature later on into the report, where we went to Toronto for the Council on Governmental Ethics Laws conference, annual conference, and then I had strep throat and a number of other things came our way. So I apologize for that high number, and I will get them done by January. So otherwise, we continued the stakeholder engagement process and appeared before 2 full committee meetings of the Sunshine Ordinance Task Force, and I also met individually with the chair of the Sunshine Ordinance Task Force on 2 occasions over the last couple of weeks in order to bring to you the innovations that I discussed earlier as to the enforcement regulations. We also appeared before the Sunshine Ordinance Task Force for a hearing on a complaint against Commissioner Rennie. The complaint stemmed from a prior finding of the Sunshine Ordinance Task Force that held this commission in violation for abridging Mr. Ray Hartz's public comment for 7 to 8 seconds last December. But the Sunshine Ordinance Task Force voted to find that it had already found Commissioner Rennie in violation, and so there was no reason to have another hearing. So we were grateful for that decision. I had a great time and learned a lot at the Council on Governmental Ethics Laws conference in Toronto. I attended countless presentations. I mean, I guess I could count them, but I didn't count them. But one for every hour and a half block, and made some very good connections with staff around the country that do the same work that we do. I especially enjoyed speaking at the local agency roundtable. I was a moderator and presenter to a group of other city and municipality council and investigators from across the country, and we learned a lot about what each of us does and the frequent problems that we encounter in our investigations. And it was good to hear ideas from those jurisdictions and to realize that we're not alone in our struggles. Our update on an investigative caseload: we only were able to open one investigation this last month, but we have again 29 matters pending our review for a dismissal. So our staff investigators are doing a great job getting through these materials, and we're hopeful that we'll be able to clear out anything older than, let's see, what month are we on now? We're looking at older than 18 months or so. So hopefully we'll get down within a year. I've asked staff to prioritize the investigations that are older than a year, so that we can get down to under a year, and complaints. Regarding the Bureau of Delinquent Revenues, they continue to move our cases toward execution, and they provide a detailed update in their chart. I will say that in December, I attended a meeting of the creditors for Lynette Sweet, who owes the city $74,000, more than $74,000 as a result of an order that this body imposed on her for misuse of publicly financed campaign funds. And that bankruptcy proceeding is proceeding. It looks like we have a chance of recovering as a result of that proceeding, but we learned that a lot of other debtors are owed money, including the Internal Revenue Service, which has priority. So we are not higher priority than the IRS, unfortunately. So I'll continue to monitor that and appear at hearings for the city. Payment plans are up to date, and then on pages 5 and 6 of the agenda item, you can see our customary charts that list the caseload statistics in graphic form, and I'll take any questions.
Commissioners.
Chair Kuehn.
Yes, Commissioner Chu.
In your write-up on Kogel, the New York City Campaign Finance Board, the director talked about using data to investigate and uncover wrongdoing by collecting and categorizing data. Is this something that we could do here?
I think so, yes. We actually track and require disclosure of a lot of the same information, and we dump it into a portal called SF Open Data, where we can put in criteria and search for all kinds of different information. So to some extent, my investigators are doing that already, but I did get ideas from that speaker about sort of red flag issues to look for in the data, and she presented a couple of case examples of where she used those red flag data to dig deeper, to get at dark money usage and coordination among campaigns. So I was excited about that presentation.
Great. Well, I hope that we can also take advantage of those red flags in their experience,
yes,
and then uncover. Hopefully, there won't be, but to use that to our advantage.
Yep.
We'll take public comment on this matter.
Sorry to be so talkative today. I wanted to thank staff for moving so forcefully on the Lynette Sweet matter. For the public's interest, this was a 2010 public financing support that we extended to Ms. Sweet as a candidate for Board of Supervisors. This has been in abeyance far too long, given our mandate for concurrent and proactive enforcement. Obviously, now the matter is in bankruptcy court, and I had a question. Since these were public funds that were absconded in part with, have we submitted to the court that fact? And that as a result, does it put us closer to the IRS than not? Because otherwise, public funds may have been lost.
A secured creditor of highest priority.
Yeah.
And we are not. We're just, the municipalities are just not in the bankruptcy code specifically. We're just a general creditor, the same way that anybody else would be with
And
unsecured
this is
debt.
a U.S. court.
Yeah, United States Federal Court for
Right.
bankruptcy.
So, well, at least we'll get due process.
Hopefully.
One way to view it. Thank you very much.
Any further public comment? Okay, if not, we'll then move on to item 9, discussion of the executive director's report.
Thank you, Chair Keene. I have on agenda item 9 a brief report summarizing some of the things you heard from Deputy Director Bloom about our attendance at the COLA conference. It was exciting to have a strong showing of staff members there who were not just passive participants, but actively shaping conversations around leading practices, challenges of implementing and enforcing local ethics and campaign finance and lobbying laws. So we very much look forward to the opportunity to send additional staff to additional sessions down in the years ahead. I did want to highlight one note of a report that we were asked to submit to the acting mayor's office after the executive director's report was complete, because it does speak to some of the items under discussion today. And I will be happy to make that available to those beyond the commission. But we were asked on Wednesday by the mayor's chief of staff to provide to his office for the acting mayor's briefing a continuity of work report. And this specifically asked for 3 things. One was, what were the items where there were key deadlines or milestones coming up that were a priority for the department in the next 30 days, also in the next 6 months, and then also in the next 12 months. And just to highlight briefly what we provided, in the next 30 days, we cited the focus on successfully implementing our new laws that become effective or become operational on January 1. This includes implementation of Prop T, the lobbyist measure that bans campaign contributions from lobbyists, bundling, and giving of gifts. And we also noted the implementation of the Supervisor Peskin's behested payments reporting by board and commission members. Both of these are significant because they are requiring us to complete those technological innovations to enable the disclosure requirements to be in place. Stephen Massey and team have been working throughout the office to make that happen in a digital format wherever possible. So that's ongoing. We also know that we need to provide those who are affected by these laws with information so that they understand them, that they're aware of it, and they know how to comply. For the items that we identified for the next 6 months, the main focus we cited was advancing our core legislative initiatives to secure their enactment. So in addition to providing effective election-related compliance guidance to those who are affected by the upcoming expanded elections in the 2018 cycle, under the legislative initiatives that we need to advance, we cited 2. One was the anti-corruption and accountability ordinance that the commission has just referred, and then secondly was the whistleblower ordinance that we needed to also make sure we were helping to move that along. So those are the 2 priority legislative items that we noted. And then thirdly, the election 2018 work under the leadership now of Gayatri Taikandil, our new Chief Programs Officer, and her team. And then lastly, for the coming year, we did cite, they asked for issues or items that were going to require, that they called were potential threats, where there might be some issues or concerns, and then other top priority. And the first, in terms of a potential issue, is the sufficiency of the election campaign fund. So this speaks to Commissioner Kopp's point earlier, that we need to make sure that we are assessing the fund. We want to make sure that it has adequate funds to sustain the levels for now a June 2018, as well as a 2019 mayoral election, as well as the 2018 November election. There is language in the city law that requires additional funding to be deposited into the election campaign fund when there is a vacancy in the office of the mayor. So we'll be working with the city attorney's office and the controller's office to make sure that we have all of those bases covered. But it is something we need to pay attention to fairly soon. And then secondly, a major milestone for us is the ICT systems development, all of those technologies that are in place and moving along to help convert our paper files to an electronic environment. So those are the items that we included for information for the briefing of our new acting mayor. And then lastly, on the two other items from the executive director's report that I would highlight. We have made very good progress this week on our hiring-related work. I will have some very good news in probably later this week to share with you and others about one of our technology positions. And tomorrow and this week we have we're focusing on moving the auditor, senior auditor, and senior investigative position further along through the exam assessment and interview process. So we will continue to proceed on that front. And as I noted, Stephen Massey, who has been acting as our key on all things technology, just effective today was moved into the principal position for that division. It had been reclassified as part of the budget, recognizing the expanded technology work that we need to do that's fundamental to all of our work. And we had a competitive position-based or exam-based process for that. And as a result of that, Stephen was the successful candidate and is now today effectively moved to an expanded position which recognizes the work and the increased responsibility for supervising a broader number of people. So the position he's just vacated will now also become one that is posted, and it will be an exam-based position as well. But there is progress. We do want to thank Doris Lorio, who's been working with us on through the Department of Human Resources under our work order for the past year. She's been very much a good and strong and steady ally in moving this process as far as it's come. We know that we will be relying on the Department of Human Resources in the coming months to continue to get these other positions past the post and get people in seats so we can do the job that we know that we have to do. And then...
Commissioner Chu.
Yes.
So, Director Pelham, since we are losing the services of Ms. Lorio, is that going to negatively impact the ability to fill these 7 positions? And, would it be possible, since I believe there would be salary savings from the open positions, to engage her for another quarter out of those salary savings?
It's a very good
yes,
it's a very good suggestion, and we have a meeting that we're setting with the Client Services Division of the Department of Human Resources to make sure we identify exactly what the needs are so that we can identify how we need to fill them. We do know we need to continue to put resources on them because when there are exam-based positions to hire, it requires a significant amount of work and support from DHR to accomplish that. Our goal is to not let it slip up in any way in terms of priority emphasis. So just one other note on the budget. For the January meeting and on into February, we will be preparing for you the budget that will be required to submit at the end of February. The mayor's office in early December gave us 2 targets, asking all departments to cut 2.5% in the FY19 and again in FY20. And for us, those targets would be roughly a $100,000 cut in FY19 and almost $200,000 in FY20. Because we are 90% salaries, as a department, we have very little overhead. This would require us to lose positions. And in my view, we are ramping up. We not just need to have positions, which the mayor's office in the past and the Board of Supervisors have supported and embraced, but we need to make sure those positions are filled and people are in their seats doing the work, trained to do the work, and with the tools to do the work. So that will be the focus of our budget request that we bring forward to you in January. And I'm hopeful that with the continued support of the leadership from the board that has embraced this, that we will show that we are a good investment for the work and the resources that the city has been committing to us. So we'll have more of a discussion on that, of course, in next month. As we approach the end of the calendar year, I wanted to just take a note to convey deep thanks to our staff who have been working hard to try and support your process during the course of the year and the public's information. We have some folks here today around this table and in the room with us, but I just wanted to take a note to say how much we've got a terrific team, and we're very, very pleased to see, I think, the work that's being done. We have a lot of work to do ahead in 2018, but I think I'm hopeful that you share the same enthusiasm I do about the folks that have been working very hard this year in support of our mission. And then just lastly, obviously, with the mayor's passing this week, the staff and I spent some time reflecting on public service and the significance of a lifetime contribution by Mayor Lee. And we just wanted to note that we do share our deepest condolences with his city family, his colleagues, his staff in the mayor's office that we've worked closely with, and of course with his family. And we just want to make sure that we take note how much we honored his contribution to the city, and will continue to be inspired by those who serve a lifetime in public service. So I just wanted to end on that note. Thank you.
Thank you, Director Pelham. Commissioners? Okay, we'll take public comment.
I'm Bob Planthold. I guess some of us on this side of the podium are concerned about the possibility of reduction in budget when you're, as your director said, trying to ramp up. I think it's possible for you to still pass your budget at your February meeting if you seek an extension, and that's been done a couple times before by ethics. Meeting on the 16th is close enough to the initial deadline that it's been granted before. And I'm bringing that up because I suggest it may be worth looking at how much progress there's been in the past year and a half towards reducing some of the backlog of complaints, towards reducing some of the analyses on pending legislation, regulation, enforcement proceedings, and therefore saying we still have staff we need to hire to bring all these backlogs to zero, to keep us current and timely, to put out a case that 2.5% per year is inappropriate. It would put you going backwards. It would not keep you where you are. It would push you backwards. If you have some sort of statistical report showing what you've gained, what you still need to reduce, and therefore find a way to, I guess I will say, impress the supervisors to not cut you by 2.5% or 5%. Thank you.
Thank you. There being no further, oh, I'm sorry, Mr. Bush, pardon me.
Larry Bush for Friends of Ethics. We also want to note on behalf of Friends of Ethics that we posted on Facebook our recollections of the work that we had done with Mayor Lee going back many years, that he had supported all of the ballot measures that came out of, or he at least didn't oppose any of the ballot measures that came out of ethics in the last several years. He supported full funding. My first time of bringing him here to ethics was back around 1992 when he was the chief administrative officer, to come and give a tutorial to the ethics staff about how to monitor city contracts and in coordination with the Ethics Commission. So he is a man who did understand and support the work that we were doing. I think that in terms of the budget and looking ahead, as I recall, budgets are ordinances, and you would have the ability to put full funding for next year on the ballot in June to take effect on July 1st. And you might want to have that as a fallback position in the event that it appears that you would reduce your staff or reduce your ability to get things done. Because I certainly support, and I think the public will support, full funding for ethics. Thank you.
Good observation, Mr. Bush. Any further public comment? Okay, if not, we'll then move to item 10, discussion and possible action regarding status of complaints received or initiated by the Ethics Commission. I think Commissioner Kopp, you have.
Yeah, I request a closed session on it.
Is there a second to the request for a closed session?
I'll second it.
All right, so motion's been made and seconded. We don't need public comment on that, do we?
I don't think so.
I don't think so. Okay, all those in favor of the motion? Oh, we're going to get it anyway.
FOE just wants to wish you all a happy holiday season. Thank you very much for your amazing work this year and how, as a unit, you have come together so well. And I think the public is aware of what it is you're doing for the city. And I think by and large, seeing us on TV is sometimes hard, but they appreciate what it is we're doing. So thank you again.
Thank you, Charlie.
And have a good holiday season. And while you're in executive session, I hope somebody brings in a box of cookies or something.
You were going to bring pizza, remember last
Yes,
time?
we discussed pizza,
Right,
but
yeah.
actually.
And I'm
Christmas-
sure the chair will deem that germane to item 10 on the calendar.
Totally.
Yes, yes. Christmas cookies would be good. Thank you.
Thank you.
Thanks.
All right, so we,
SF Gov TV, San Francisco Government Television. SF Gov TV, San Francisco Government Television. SF Gov TV. San Francisco Government Television.
Ever wonder about programs the city is working on to make San Francisco the best place to live, work, and play? On this show, we bring some shine to the most innovative ideas brewing within our city departments and the people making them happen. Join us for an exclusive look at what's next inside this episode of What's Next SF. San Francisco. Known for its landmarks, history, and beauty, this place arguably has it all. But its city government is also pretty unique. In fact, San Francisco city departments are filled with truly innovative programs that are impacting the city in really tremendous ways.
Our goal is to create programs that are easily digestible, that are easy to follow, so that our residents can participate in healing the planet.
With the new textile initiative, they're getting awful close to their goal of zero waste by the year 2020. And today, San Francisco is diverting over 80% of its discards from landfills, more than any city on the planet. And while these numbers are impressive, they're not quite enough.
We are still sending over 400,000 tons to the landfill every year. And of those 400,000 tons, 20,000 are textiles.
Items such as used clothing, unwanted linens, and old shoes no longer have to be dumped in the trash. Luckily, SF Environment has found many outlets for these items.
ICO, which stands for I Collect, they are the ones creating the partnership directly with the retail clothing stores. And they're putting in-store collection boxes right next to the checkout stand. So when customers come to the store to go shopping, they can bring their used clothes of any brand to those stores and drop it off.
And for added convenience, textile collection bins will become accessible in apartment buildings throughout the city.
The other partnership has been with Goodwill, and we have a zero waste grant with them for them to design a textile collection box, especially for multifamily settings.
Goodwill, the well-known thrift store, has been making great strides for our environment and our community.
We're very thankful for people who donate clothing and other household items to Goodwill. The funding for all of our job training and placement programs comes from us selling those items in our stores. But that process also helps to divert more than 21 million pounds of things from local landfills every year here in the Bay Area.
And Goodwill's textile collection box is going to take them one step further in their efforts of helping San Francisco reach zero waste.
So the Go Bin is a new bin that we have designed and are manufacturing, and it brings the donation opportunity right to the donor, making it as convenient as possible. The Go Bin is going to be one of the solutions to make sure that we're capturing all the value in those textiles and they're not going to waste.
With the help of Goodwill and other businesses throughout the city, San Francisco aims to eliminate 39 million pounds of textiles from the landfill next year. And SF Environment is confident.
There we are.
Okay. We're back in open session for the Ethics Commission December meeting. And is there a motion in regard to what we did in our closed session pursuant to item 10?
I would move that we treat the comments closed session in confidence.
Is there a second?
Second.
All right. All those in favor of the motion?
Aye. Aye.
Opposed? All right. The motion passes unanimously. Okay, so we then go to item 11, discussion and possible action on items for future meetings. I think some of the things that have come up tonight indicate things that we'll be doing at future meetings in regard to putting matters on the ballot. And just listening to what has been said, I would anticipate that in February we would be we would have agendized putting on the ballot the whistleblower item, and also our ordinance that we passed the last time so that we get it on the ballot, both of them on the ballot in June, and have them effective as soon as possible. The third thing, which did come up tonight, and I think it would probably be important unless we get some sort of indication from the city, the danger of the budget of the Ethics Commission being cut at this point when we've been able to protect it so fiercely the last few years, I think is fairly substantial. I mean, we used to be not protected at all under the former executive director. We've done it with the executive director, and also indicating from the commission that we would go forward with an ordinance relating to the budget if they didn't pass our budget. So I think we ought to think about it, but also adding what was recommended by Charlie Marstetter, and that is that we also put a measure on the ballot in June that the commission be fully funded, because we are now up and running. We're starting to get going, and to have a hole in the budget at this point would be, I think, a very sad thing to happen and a very destructive thing to happen. So I'm just ruminating out loud regarding things that I would like to see perhaps agendized for February. Commissioner Cobb.
I've never asked the executive director or you, Mr. Chairman, about a member requesting an item on the agenda. Can that be done outside of our public meeting?
Yeah, a member can request it, and then there would be a discussion between Director Pelham and me as chair, and the likelihood, I can't see that I would not accede to that request.
All right, I will defer.
Very good.
Till the new year.
Okay. Any other discussion on matters for future meetings? Any public comment on that?
Actually, I have one.
Oh, I'm sorry.
So, I'm sorry, just in reflecting on your comments, Chair Keene, about the budget, I think if we were to explore a ballot initiative relating to the budget for the Ethics Commission, I would suggest that we explore a little more broadly, that not just for this upcoming fiscal year, but that we look at independent funding for the budget, so that we wouldn't necessarily always be subject to 5% to 2.5% decrease over time, but that if the budgeting process for the commission could be, I don't know how this would work, and that would be, I think, the work to be done, would be to have it on a standalone basis and have approval be, whether it's through a voting mechanism, like through the public or through a mayor, but just some alternative mechanism that could help preserve the integrity of our budget. Because as I think back and reflect on where we started from when I joined the commission, we were sorely understaffed, and we have been chronically understaffed over the past 12 months, if not longer. And that we were able to preserve the budgets. We were able to get increased funding, but with a 2.5 decrease in the upcoming fiscal year and the subsequent year, it would completely gut the strides that we have made in building up the team to be able to do the work. And I take Mr. Planthold's suggestion to use the data to show the backlog of complaints. And when we began this work, there were complaints stretching back to 2014, right? And now we're on the cusp of 2018, and we've brought that down, and that we don't have things pending from 2 years ago or from 18 months ago. And so I think that would be very powerful evidence to suggest that the staffing and support and resources that the city has committed to us, and I think the Mayor Lee was instrumental in that when cuts were being asked for across the board. He didn't mandate that we had to go along with those cuts, and I think that's part of his legacy is this support for the commission. And so I'd like to explore ways in this upcoming couple of months to see whether or not that support can be institutionalized in some legislative fashion that would help preserve the independence and the integrity and the resources that we have to do the work.
I think that you've made a very important point in regard to Mayor Lee, that since we've been started emphasizing it to a couple of years ago, he has always been responsive to that. But now we have a whole new day, and everything starts from zero in San Francisco when you get a shakeup like this. And so the new mayor, whatever the Board of Supervisors' views are, they're not necessarily going to, or at all going to reflect what Mayor Lee's been doing. So these are things I think that we should definitely do in order to institutionalize what we've done so far. Okay, any other thoughts on that? Okay, so additional opportunity for public comment on matters appearing or not appearing on the agenda pursuant to Ethics Commission's bylaws, Article 7, Section 2. I see no public comment. Then I suggest, Commissioners, that someone make a motion to adjourn, and to adjourn in the memory of Mayor Ed Lee, who was, and the significant loss that we've had with his passing. I knew Ed Lee since the 1980s when I was president of the Bar Association of San Francisco, and he headed the Asian Law Caucus and was involved with him in a number of matters over the years. And he is someone who made a big difference in regard to our community, and I would entertain such a motion Commissioner Lee has made the motion. Is there a second?
Second.
Second. All those in favor say aye.
Aye.
Aye. Okay, the motion passes unanimously.
Wishes to the staff?
Yes.
Oh yeah, best wishes to everybody.
Same place?
Same place.
Try
No,
something
the same
else?
place. It's